On a hot day last August, after being asked what I was going to talk about today, and when February seemed a very long time, a long way away, I thought I might reflect on a famous statement that James Madison made in Congress on April 6, 1796, with regard to the significance of 18th century sources in interpreting the Constitution. I had decided at the last minute, and in truth not so long before that day in August, that I would include Madison's statement as an epitaph in Ratification, The People Debate the Constitution, 1787 to 1788. For an obvious reason, I was interested in selling books. And nobody with similar authority has ever made a more powerful case than Madison for the significance of my subject, the debates in the state ratifying conventions. Madison said that whatever veneration might be entertained for the body of men who formed our Constitution, the sense of the Federal, or if you like, Philadelphia Convention, could never be used as an oracular guide in expounding the Constitution. And he went on, as the instrument came from them, it was nothing more than the draft of a plan, nothing but a dead letter, until life and vitality were breathed into it by the voice of the people, speaking through the several state conventions. If we were to look, therefore, for the meaning of the instrument beyond the face of the instrument, we must look at it not in the General Convention, which proposed, but in the state conventions, which accepted and ratified the Constitution. In short, Madison asserted that the meaning of the Constitution beyond the face of the instrument, that is, where its words were insufficient, should be sought not in the records of the Federal Convention that produced the document, but in the records of the various state conventions where we, the people of the United States, ratified it. Aside from including Madison's statement, I said nothing in the book about the significance of the ratifying debates for modern interpretations of the Constitution. Attempts to show the relevance of a historical narrative for contemporary controversies often end up dating a book, I think, and particularly a book like Ratification that was some 220 years in coming and could be a handbook for historians and jurists for some years to come. Moreover, although my credentials as a historian are, I think, reasonably strong, I am not a lawyer or an expert on American constitutional law as it has developed over the past 2 centuries, and I am certainly not a legal theorist. Theory is not my thing. I therefore let the book be what it always was meant to be, a narrative history whose primary interpretive contribution is historical, in the way it describes the politics of ratification within the 18th century. Others, of course, might draw lessons from it, but the book itself stands determinedly neutral with regard to its current implications. And yet, Madison's statement intrigued me, and there seemed to be no reason not to reflect on it elsewhere if the opportunity arose, as it did with the invitation to give this lecture. So today I will begin by looking closely at Madison's statement, the context in which he made it, and its theoretical foundation, then go on to consider briefly how, as I see it, the statement relates to the current debate over originalism in interpreting the Constitution. Finally, I will reflect on whether Madison's dictum has any enduring significance for interpretations of the Constitution today. In all parts of this talk, however, I will speak as a historian who, like all historians, is not intimidated by documents, including legal documents, which are now so easily accessible to anyone with a computer and an internet connection. And I understand that is risky. I remember well Jefferson's contempt for people who read Blackstone and thought that they knew law. What would he say about those of us who get much of our law via Google? On the other hand, there might never have been a time when history and law have been so close as they are today, or when a historical perspective was more useful in making sense of several critical constitutional issues. Let's start with Madison. Like many modern commentators on judicial interpretation, he saw the words of the Constitution as primary. Only when the meaning or implications of its words were open to dispute did he propose consulting the debates in the state ratifying conventions. That there would be a need to go beyond the face of the instrument followed logically from the nature of a constitution, which, as Edmund Randolph advised the Federal Convention's Committee of Detail in July 1787, could include only general principles expressed with simple and precise language, not detailed prescriptions that might prevent its being accommodated to times and events in the future. Connecticut's Oliver Ellsworth later added that the Constitution was written with brevity and in the plain common language of mankind, so the people who were to be its judges could understand it. But the Constitution's dependence on general statements and lack of provisos and qualifications of a sort lawyers and legislatures in certain ordinary laws also meant that Americans would have something less than clear marching orders when applying those general prescriptions to specific times and events. And such instances were quick to appear. In the 1790s, as Congress set the new government into motion, it repeatedly faced a need to interpret the Constitution to fill the gaps in what it prescribed, and it groped for rules to govern that effort. The Constitution said officers of state would be appointed by the President with the advice and consent of the Senate. But could the President remove such officers from office without the Senate's consent? Was it for Congress to decide that issue, or should it be left to the courts to decide after an aggrieved former office holder brought suit? Was the creation of a national bank a necessary and proper measure for carrying out the fiscal powers explicitly granted to Congress under Article 1, Section 8? Later, in the mid-90s, after John Jay negotiated a treaty with Britain that affected foreign trade, the House of Representatives claimed that it should have a say on treaties, particularly when they affected Congress's power to regulate commerce. The controversy moved into high gear in March 1796, when President Washington requested funding from the House to implement Jay's treaty, and in response, the House demanded the diplomatic papers that would throw light on the treaty. In the ensuing debates, both supporters and opponents of the House's claims cited the Constitution, the Federal Convention, and the several state ratifying conventions, an early indication of how indecisive those sources can be in resolving specific controversies. Finally, in refusing the House's demand, Washington noted that the Federal Convention had specifically rejected a motion to give the House of Representatives a role in treaty making, and that, it seems, provoked Madison's statement that authority over the meaning of the Constitution lay not with its authors, but with its ratifiers. In truth, however, Madison's effort to cite debates in the state ratifying conventions to support a role for the House of Representatives in treaty making was unpersuasive, even in the opinion of a historian who is perhaps his greatest living admirer and who will be here in the fall, I've learned. The words of the Constitution, after all, say unambiguously that the President shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And there's no reference to the House of Representatives. In effect, the words of the Constitution trumped his effort to interpret them in ways that were at odds with those words. Madison's statement was then at least partly politically motivated. It also reflected in some measure the fact that in the spring of 1796, the records of the state ratifying conventions were more readily available than those of the Federal Convention. The official journals of the Federal Convention, which were poorly kept by its irresponsible secretary, William Jackson, who was something of a rake, would not be published until 1819. God knows how he got that job. I'd like to figure that out. Maybe you can tell me. Madison's more detailed notes of the debates remained in his possession, would not be published until 1840, 4 years after his death. That meant citations of what happened in Philadelphia during the summer of 1797 depended on the notoriously unreliable memories of those delegates who had been there. And that was hardly a respectable basis for interpretations of the Constitution. By contrast, the official journals of state ratifying conventions had been published soon after they met, as were accounts of debates in those states where they had been recorded, including Pennsylvania, Massachusetts, Virginia, and North Carolina. The published debates were imperfect. They depended upon the skill of stenographers who took them down, the debates down for publication in newspapers or in the form of books that would be sold to an interested public. The debates were also often politically biased in favor of the Federalists, who often hired the stenographers and owned the newspapers that printed them or subsidized their publications as books. The most egregious example is the published debates of the Pennsylvania Convention, which include only the speeches of two leading Federalists, as if nobody else was there. The printed debates also suffered from the stenographers' difficulty hearing or understanding what was said, or their occasional absence from the proceedings. Madison, for example, said that David Robertson's relatively even-handed 600-page account of the Virginia debates in which Madison took part contained internal evidence of chasms and misrepresentations of what was said. But those records existed, and they were available to congressmen in 1796. In fact, House members also cited the Maryland Convention that had no official debates, but they depended, I take it, on retrospective accounts by delegates who were on opposite sides of the divisions in that convention. Well, for us, or I should say for most of the 20th century, the availability of information on the federal and the ratifying conventions has been, was dramatically different. The 20th century is over, isn't it? Beginning in 1911, scholars and jurists have had access to Mac Foran's authoritative edition of the records of the Federal Convention. Foran collated the convention's journal and Madison's notes with more fragmentary records of debates kept by other delegates, and so provided, I think, about as good an account of what was said day by day as we're likely ever to get. By contrast, those who wanted to know through most of the 20th century what happened in the state ratifying debates were still relying on Jonathan Elliott's edition of the debates in the several state conventions on the adoption of the federal Constitution, which had first appeared between 1827 and 1830, and reproduced the original accounts of the debates even when Elliott fully understood how seriously inadequate they were. In a 1987 evaluation of the documentary record, James Hudson of the Library of Congress added to the list of flaws in the state debates that I've already mentioned. Speakers, he said, were sometimes allowed to correct speeches presented in the conventions before they were printed, and some speeches, he claims, were simply fabricated. The record was indeed so corrupted, Hudson concluded, that it would appear impossible to rely upon the documentary record to discover the intentions of the framers. I think, however, that Hudson's judgment is no longer valid, and the reason is the documentary history of the ratification of the Constitution, a massive editorial project from the University of Wisconsin that has turned out an impressive number of additional volumes since 1987. It now is 21 volumes in print, of which 14 cover in detail the ratification of the Constitution in 7 states, including Pennsylvania, Massachusetts, Virginia, and New York. The DHRC collates the journals and published debates of the state conventions, that is where there are records of the debates, with more fragmentary records kept by delegates and other witnesses to them. newspaper articles, and letters describing the proceedings. No equivalent of many of those documents exist for the Federal Convention because its debates were, of course, secret. And the delegates couldn't write letters, and nobody could sit in there and listen to them and say, let me tell you what happened today. And by collecting, I think, and collating all those sources, the DHRC makes it possible as never before to figure out what happened. To be sure, the documentary record is imperfect, but so are all historical records. Nonetheless, the DHRC allows us to see the structure of the debates in the state ratifying conventions, how they differed from state to state, to identify which issues provoked controversy and which did not, and to see how Federalists explained ambiguous passages and how other delegates reacted to those explanations, all of which seems to be of fundamental significance. That development makes it, in short, possible for jurists and historians, starting with me, to turn to the ratification debates, as Madison recommended. His recommendation, moreover, was built on a very strong theoretical foundation. The Federal Convention had no authority to write a constitution, much less put it into effect. It had been called and authorized by the Confederation Congress, and also generally by the state legislatures that appointed delegates for the sole and express purpose of revision of the Articles of Confederation in ways that, when approved by Congress and the states, would render the federal Constitution adequate to the exigencies of government and the preservation of the Union. The delegates later justified their extraordinary disregard of their instructions by saying they decided they couldn't add powers to a government in which all of that power would be invested in simply Congress, as was the case under the Confederation. Only a new form of government with separate legislative, executive, and judicial branches could be entrusted with substantial power. In any case, its unauthorized proposal was, indeed, a dead letter until the specially elected state ratifying conventions, which were authorized to act in the name of the sovereign people, enacted it. For that reason, congressional contenders on both sides seemed to agree in 1796 that, as Rhode Island's Senator Benjamin Bourne put it, the opinion of those who ratified the Constitution, what they thought they were agreeing to, should determine its meaning, where its words were indecisive. What is theoretically correct might not, however, be practical. Some readers of ratification have seen the robust disagreements of the ratifying conventions as evidence that there never was any original understanding of the Constitution, and so a standing refutation to all originalist theories of interpretation. Let me cite, for example, a conclusion Jack Rakoff drew in a very thoughtful Harvard Magazine review of my book, with which I should say I was extremely pleased. In an understated way, he said, the book cautions us not to ascribe too much authority to the opinions expressed in 1787 and 1788. The original understanding of the delegates to the ratification conventions were filled with gaps and misconceptions the debaters never resolved. Inadvertently or not, he said, Maier's account of what was actually said explains why latter-day originalists, like Justices Antonin Scalia and Clarence Thomas, who treat the final text of the ratified Constitution as sacrosanct, reveal so little serious or sustained interest in the actual debates that adopted the Constitution. Indeed, why originalists now prefer to play language games about what the Constitution must have meant to ordinary readers than reconstruct how it was actually framed and debated. Rakoff is not alone. Another legal historian took particular delight in the book's epilogue, which points out that the rights of greatest concern to the Constitution's critics in 1787 and 1788 were not those we care so intensely about. That many leaders of the opposition considered the amendments the Constitution proposed in 1789 as far from adequate, and that nobody called the 10 amendments that were finally ratified a Bill of Rights. Those revelations, he said, undercut the premises of originalism. Well, here it isn't, in this company, it's not going to do to go forward, as I gather some of my historical colleagues have done, on knee-jerk assumptions about the meaning of originalism. So I try to go beyond them. And you don't have to venture very far into the literature to learn that there are profound differences between those who have advocated basing interpretations of the Constitution upon the intent of those who wrote and or ratified it, and those who would use historical sources more narrowly to understand the words and phrases used in the text of the Constitution. In a matter of interpretation, Federal Courts and the Law, which was published in 1997 and remains the fullest statement of his legal theory, Justice Antonin Scalia, arguably the most articulate originalist on the Supreme Court today, explicitly rejected consideration of the intent of those who drafted the Constitution in interpreting its meaning, and instead advocated what he called a rigid textualism. I will consult the writings of some men who happen to be delegates to the Constitutional Convention, such as Madison and Hamilton, he said, not because they were framers and therefore their intent is authoritative and must be the law, but because their writings, like those of other intelligent and informed people of the time, display how the text was originally understood. In interpreting the Constitution as in interpreting a statute, he said, he looks for the original meaning of the text, not what the original draftsman intended. Although he understood that there is room for disagreement on the meaning of a text, Scalia insisted that holding close to its words restrains judges from reading meanings into the Constitution that were never there. And that, he insisted, is a worthy goal because unrestrained, creative interpretations of the Constitution by the Supreme Court over previous decades had imposed one new restriction after another on elected institutions and so constrained the power of American democracy. But has the effort to recover the original understanding of the Constitution resulted in greater judicial restraint and faithfulness to the words of the Constitution? Here it's worth noting once again that Scalia's original understanding is not new. It resembles what Chief Justice John Marshall described in 1827 as rules of interpretation that had been repeatedly affirmed by the Supreme Court, that the intention of the instrument, that is, of course, the Constitution, must prevail, that this intention must be collected from its words, and the words are to be understood in that sense in which they are generally used by those for whom the instrument was intended. Marshall added, however, that the Constitution's provisions are neither to be restricted into insignificance nor extended to objects not comprehended in them nor contemplated by its framers. And those kind of make your mind go blank. But I think the last phrase of that sequence opened the possibility of going beyond original understanding to considering the original intent, and Marshall did that. That is, he considered not just the words of the Constitution, but the original intent, with devastating results in Barron v. Baltimore, critical case of 1833, when the court decided that the Fifth Amendment, and by inference all of the first 10 amendments, applied only to the federal government, not to the states. Marshall based that decision in good part on his memory of the ratification of debates in which he had participated as a delegate to the Virginia Convention. Serious fears were extensively entertained, he recalled, that the new powers of the Union might be exercised in a manner dangerous to liberty. The first amendments to the Constitution, he claimed, were proposed by Congress and adopted by the states to quiet those fears. These amendments, the court said, contain no expression indicating an intention to apply them to the state governments. This court cannot so apply them. But Justice Marshall. The amendment at issue also contained no words indicating that it bound only the federal government. It began, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury," and ends, "Nor shall private property be taken for public use without just compensation." Only the First Amendment, which begins, "Congress shall make no law," and the Seventh Amendment, which applies to the right of trial by jury in federal courts, were so constrained. The Sixth Amendment begins, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed," which, like the Fifth Amendment, could well bind both the federal and the state governments. Indeed, all the rights amendments protecting specific rights, except the First and the Seventh, 6 of 8 are stated as general principles. The fact that they were not expressly confined to federal institutions, as others were, could well imply that they were not so constrained. Now I invite you to imagine a world in which Marshall had paid close attention only to the words of the amendments, without his undocumented pronouncement on the original intent. What that would have done to the history of American jurisprudence. If in 1833 the court had made the Fifth Amendment and most other rights amendments binding on the states, the need for litigation using the 14th Amendment for that purpose would have been substantially reduced. More recent applications of original understanding give evidence of a similar disregard for the words of the Constitution, even among self-professed textualists. The theory no doubt explains the peculiar form of the majority decision in District of Columbia v. Heller, 2008, which Scalia wrote. In keeping with his expressed desire to understand how the words of the amendment were understood by intelligent and informed people of the time, the decision engages in a somewhat bewildering effort to parse the words and phrases of the amendment, citing a relatively random set of sources to show that it confirmed a pre-existing individual right, quote, "to possess and carry weapons in case of confrontation." On the basis of that effort, a prime example, I think, of the language games to which Rakoff referred, the decision argues that the Second Amendment descends from a provision in the 1689 English Declaration of Rights that said, "The subjects which are Protestants may have arms for their defense, suitable to their condition and as allowed by law." But the right asserted there to have arms for their defense was not a basic individual right, since it was restricted to Protestants who could not only own arms, who could only own arms suitable to their condition, that is, their social rank. More important, the words of the English provision are different from those of the Second Amendment, which says, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The majority opinion argued that the verb keep, along with bear arms, indicates that the amendment had an individual as well as a collective military meaning. For support, it put great emphasis on provisions in the roughly contemporary Pennsylvania and Vermont constitutions that said the right of the people to have a right to bear arms for the defense of themselves and the state, or affirmed that right. And the court dismisses more common statements that the people had a right to bear arms for the defense of the state, North Carolina, 1776, or, mind this, to keep and bear arms for the common defense, Massachusetts, 1788, where the phrase "to keep and bear arms" clearly, to both verbs, referred to collective action. The real question, however, is not about this random use of references. The question is whether the citations have any relevance in explaining the words of the federal provision, which contains no reference whatsoever to self-defense, or for that matter, to confrontations that threaten individuals. What the majority opinion in Heller did, in short, was to read a right to self-defense into the Second Amendment, and that's hardly consonant with either Madison's or Scalia's theory of interpretation. Heller and the Supreme Court's more recent decision, McDonald v. Chicago, 2010, also did precisely what Scalia condemned in 1997, affirm a right that constrains the power of elected legislatures to restrict or outlaw the ownership of guns in ways that they and their constituents think will best serve their safety and welfare. To discover the original meaning of the right to bear arms among ordinary intelligent Americans, the state ratifying debates are a more appropriate place to look for than scattershot quotations that are often only of anecdotal significance. After all, the state ratifying conventions brought together elected delegates specifically to represent their constituents' convictions on the proposed Constitution. They therefore provide a systematized statement of public sentiment. It could be, however, that Scalia's law clerks rummaged through the ratification debates, but were very frustrated by the lack of any statements there affirming the right to own a gun, or for that matter, the right to own a horse. A negative result is, however, a result. And there is an obvious reason why they would have found no such references. The ratifying debates discussed the Constitution, and so the proposed power of the federal government, and nobody dreamed that such issues would fall under federal jurisdiction. The right of individuals to defend themselves, quote, in cases of confrontation, unquote, fell within the powers of internal police, the regulation of people's day-to-day interactions that the states firmly and explicitly reserved to themselves. Pennsylvania. The Pennsylvania Constitution, for example, 1776, declared that the right of this state, that the people of this state have the sole, exclusive, and inherent right of governing and regulating the internal police of the same. Hunting similarly fell in within the province of the states, and so was appropriately protected there if it seemed important to do so, as was apparently the case in Pennsylvania. The lack of discussion in the ratifying conventions is therefore significant. A federal constitutional amendment would hardly have been framed to answer a non-existent concern. The ratifying conventions do, however, give abundant evidence of a widespread concern over giving Congress power to raise and support armies and to provide for organizing, arming, and disciplining the militia, which it could call out to execute the laws of the Union, suppress insurrections, and repel invasions. Americans shared a profound and well-documented conviction that standing armies in time of peace are dangerous to liberty and so should not be allowed. Some conventions proposed without a 2/3 or, for New Hampshire, a 3/4 vote of Congress. If Congress's army raised the specter of military rule, the remedy, people thought, was the militia, an amateur local defense force drawn from the entire adult male population. But Congress could destroy the militia, George Mason argued in the Virginia Convention, by failing to arm the militia adequately or making service in it disagreeable, dragging militiamen from Virginia to New Hampshire, for example. Never thought they'd go to Iraq. Federalists never disputed those basic assumptions. They argued only that the fears for the future of the militia were misplaced. In 18th century laws, I will add prefaces, or with the Second Amendment, the opening phrase explained the purpose of an enactment. Thus, the people's right to keep and bear arms was understood to assure the continued existence of the militia, which was critical to the security of a free state, as the dissenters in Heller and all previous court cases had concluded. Does that mean, I'm not going to flail this dead horse too long, but I think it's worth asking whether this means, as Scalia suggested in 1997, that the Second Amendment guaranteed nothing more than the state National Guard. In fact, it doesn't do that. It suggests that were it not for Heller, the Second Amendment would be simply archaic, a measure based on assumptions we no longer hold to protect an institution that no longer exists. 18th century Americans trusted the militia because it was an amateur force drawn from the people. It would therefore never turn against them like a mercenary professional army. The institution limped along through the 19th century until the Great Railroad Strike of 1877, when the militia predictably fraternized with the strikers rather than protect their employers' property. That provoked a professionalization of the militia, which was increasingly called the National Guard. And the National Guard became an effective strike-breaking force. Then in 1903, the unfortunately named Dick Act, named after Ohio Congressman Charles Dick, made the National Guard a backup force for the regular army with the same organization, discipline, and weapons. The National Guard is not the militia the framers knew and loved, or the National Guard could not be in Iraq and Afghanistan, since the militia can only be called out by Congress, quote, to execute the laws of the Union, suppress insurrections, and repel invasions. The militia of the founders no longer exists. I doubt that many Americans think our liberty is less secure as a consequence. Would that change of sentiment surprise the founding generation? Perhaps, but it never thought that it had enacted a wisdom that would last through the ages. For them, constitutions were not meant, as Scalia claimed in 97, to prevent change, much less to embed certain rights in such a manner that future generations cannot readily take them away. The rights at issue were limits on government for the benefit of future generations, not restrictions on them, and constitutions were meant not to prevent, but to order change. As inevitably old concerns disappeared and new ones arose, or people discovered better ways of doing things. After all, the states had begun writing constitutions in 1776, and by 1787, some were on their second or even their third constitution. The intervening period had been one of intense experimentation and development in the science of constitutions, as Edmund Randolph put it at the beginning of the Federal Convention. That process of development shaped the design of the federal Constitution. How could anyone think that the process of development was going to suddenly stop? Even the most adamant defenders of ratification, Washington, Hamilton, Franklin, Madison, left the Federal Convention in some measure disappointed with the Constitution it had produced. That made sense. The convention had negotiated a series of compromises, which by definition, leave everyone a little unhappy. At best, the Constitution's supporters said it was the best they could get at the time, which assumed it could be improved or possibly would be replaced in the future. And yet, to prevent any premature unwinding of the agreements the convention had reached only after stressful arguments, the convention demanded that the country enact the Constitution as written without changes prior to its ratification. Those who criticized the Constitution in the ratifying debates did not, for the most part, want to see it rejected. They understood that the Confederation had failed and the Constitution was a step in the right direction. But they wanted changes before it went into effect, changes that would protect the people's right to a free and equal representation, place restrictions on the wall-to-wall taxing power of Congress that, they said, would insufficiently understand the circumstances of the people, and require supermajorities for the creation of a dangerous standing army. For them, the Constitution was not sacred, it was a work in progress. And after its ratification, his attitudes toward the Constitution became more referential. Surviving members of the founding generation registered their dissent from that tendency. Some men look at constitutions with sanctimonious reverence, Jefferson complained in 1816. They ascribe to the men of the preceding age a wisdom more than human and suppose what they did to be beyond amendment. I knew that age well. I belonged to it and labored with it. It deserved well of its country. It was very like the present, but without the experience of the present. and 40 years of experience in government is worth a century of book reading, and this, they would say themselves, were they to rise from the dead. Even members of the founding generation more conscious than Jefferson of the need for political stability, John Adams, for example, or Madison, understood that the Constitution had to be tested by the experience of the future and adapted to changing circumstances. They also trusted the capacities of posterity, sometimes more than posterity trusted itself. In 1811, Adams confessed a very great secret to a younger American. So far as I am capable of comparing the merit of different periods, he said, I have no reason to believe that we were better than you are. 4 years later, he wrote an old political colleague that he could see a succession of able and honorable characters in the United States, from members of Congress down to students in our universities, who will take care of the liberties which you have cherished and done so much to support. The founders' means of change is, of course, in Article 5 of the Constitution. It made amendments easier to enact than under the Articles of Confederation, which required the unanimous consent of the states. But the Constitution's amendment process has, of course, been used very sparingly. After adopting 10 amendments within 3 years of the new government's start, the country has enacted only 17, one of which canceled out another. That's the 23rd Amendment, canceled out the 18th on prohibition. That leaves a total of 15 over 220 years. That reluctance to amend the Constitution might demonstrate, of course, a commendable respect for stability. It could also suggest, I think, that the provision in the Constitution had made amending a little bit too hard, that 2/3 vote of Congress or of a special convention to propose amendments and approval by 3/4 of the states became too difficult with the rise of political parties. But the net result is that congressional efforts to legislate on issues of national significance like environmental protection or health care have been necessarily justified under the words of a constitution written long before those issues arose, arguably pushing the Commerce Clause to the breaking point. The task of adapting the Constitution has in fact fallen largely to the judiciary, where the challenge of interpreting the Constitution is far more complex than it was for Congress in 1796, as Justice David Souter made clear in his reflections on 19 years on the Supreme Court at Harvard's commencement last year. And if you haven't read his remarks, I recommend them to you. You can get them easily on the internet, our source of information. He said the court's pronouncements are necessarily made in deciding specific cases and sometimes require reconciling conflicting provisions of the Constitution. The notion that the words of the Constitution can resolve all conflicts depends, Souter has concluded, on a very human but ultimately unrealistic hunger for certainty, control. If we cannot share every intellectual assumption that formed the minds of those who framed the Charter, he said, we can still address the constitutional uncertainties the way they must have envisioned, by relying on reason, by respecting all the words the framers wrote, by facing facts, and by seeking to understand their meaning for living people. In that eminently reasonable pursuit, the courts can now go beyond the minds of those who framed the Charter, as Souter put it, and consider also the arguments of those who ratified the document, as Madison recommended. Nor does there seem to me to be any reason to rule out respectfully consulting the records of the Federal Convention now that its debates are documented, not subject to the irregularities of human memory, and so long as the founders are not considered oracles. The founders and the ratifiers were instead joined in a partnership with future generations to create, occasionally renew, and sustain a system of government based on popular consent, dedicated to the rights and dignity of the people, as well as their security and welfare, and to maintaining the rule of law. That was how the creators and ratifiers of the Constitution understood themselves and their relationship with what they called generations yet unborn. That was the original understanding.